The broadcast is now starting. All attendees are in listen-only mode.
Hello, everybody, and welcome to today's session, Tribal Enhanced Sentencing Authority under TLOA. I'm Travis Johnson, your moderator for today's session. I'm here at APPA as a Grants Program Associate, and we are happy to provide you today's webinar through BJA grant funding. Today, we're joined by the Honorable B.J. Jones, Executive Director of UND's School of Law, Tribal Judicial Institute. Just so everybody knows, we're going to have a record this webinar, and we'll be able to make it available to you guys later through a YouTube link, and also can be found on our APPA repository website. If you want to watch it again or forward it to your coworkers, you can do it that way. Before I introduce today's speaker, I would like to state that this project is supported by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crime, and the SMART Office. Points of view or opinions in this webinar are not necessarily represent the official position or policies of the U.S. Department of Justice. All right, with that, I'll introduce today's speaker, the Honorable B.J. Jones. He has over 25 years experience as a tribal judge for various tribes in the Northern Plains area. Jones teaches criminal law and jurisdiction in Indian country and has a seminar on Indian Child Welfare Act at the University of North Dakota School of Law. Jones has presented over 200 national and regional conferences since 1995, including the Indian Nations Conference, Department of Justice events, Federal Bar Association events, and National American Indian Court Judges Conferences. And with that, BJ, I'll hand it over to you, and we can get into some TLOA stuff.
Hey, thanks so much, Travis. I want to thank all of you for participating. In addition to this being recorded, Travis can share with you the PowerPoint that I'm going to be going over during the presentation. And this is webinar 2 of a series of webinars we're conducting regarding enhanced sentencing authority under the Tribal Law and Order Act. We're in the process, APPA and our organization, in developing a curriculum that we're going to post online that gives some guidance to Indian tribes that are interested in exercising enhanced sentencing authority. As Travis mentioned, I direct the Tribal Judicial Institute, but I'm also a tribal judge at one of the tribes, Sisseton and Wahpeton, which has enacted enhanced sentencing under the Tribal Law and Order Act. So I'm going to talk a little bit about my experiences there in the passage of a tribal code to implement enhanced sentencing. I don't call it felony sentencing, although when we look at a lot of the tribes that have enacted this enhanced sentencing, they do call it felonies. There's some discussion right now about whether tribes should call these felonies, even though it meets the definition of a felony because the sentence is more than a year. But we'll talk about that. But this is as part 2 of this webinar series. I'm going to talk a lot about community input and community readiness in your tribal community to implement enhanced sentencing. And a critical part of that is enacting an appropriate tribal code that meets federal standards under the Tribal Law and Order Act, as well as standards under the Indian Civil Rights Act. So we may also have someone from the Bureau of Justice Assistance who may participate in this to field any calls. Okay, this slide shows what we're going to be talking about at this particular webinar. We're going to talk about determining whether your community is prepared or ready to exercise this sentencing. We're going to look at the Tribal Law and Order Act, what it says about what types of crimes can be subjected to enhanced sentencing under the Tribal Law and Order Act. I'm going to give you some examples of what some tribes have done to implement enhanced sentencing, and then also give some examples of what other tribes have done to provide perhaps some remedies for felony convictions or enhanced sentence convictions. It's important that if you embark upon this, that you realize that there's consequences of convicting people for offenses that many would consider felonies. So we'll talk about those. So that's kind of an overview of what I'm going to present about, but I do want to make sure we have time at the end for a discussion. There may be persons on the call that work with in tribal communities that have implemented the Enhanced Sentencing Authority under TLOA. We definitely want your input. One of the things we want to do, similar to what's happened in the domestic violence area, where tribes have been given special domestic violence jurisdiction, is to try to start monthly calls amongst all tribes who exercise this sentencing. Unfortunately, what happens sometimes in tribal communities is one tribe will do something and all tribes will be judged by that's been done. So we definitely don't want the first case that goes to the federal court challenging enhanced sentencing to be a minor infraction that a tribe imposed a major sentence for, something as littering, someone getting 9 years. I mean, we don't want that. So we all want to communicate to ensure that we're complying with federal law on this. So, all right, the next slide. Drafting a tribal code is actually easy. Before a tribe does that, though, we're stressing in the curriculum, it's critical for you to gather input in your tribal community on whether the tribe and the community want to pass these kinds of laws. I know with regard to Sisseton and Wahpeton, for example, the tribe passed a substance abuse code that felonized or it added enhanced sentencing to certain drug crimes, primarily methamphetamine. And the impetus behind this were the elders in the communities who approached the tribal council and said, we need to do something about methamphetamine. It's ravaging the community. And I'll talk a little bit later about what the tribal community did. But remember, some tribes aren't really too enthused about using punitive sanctions as a way of punishing. Many tribes I've talked to prefer to use alternatives to incarceration, alternatives to long-term imprisonment. So that's one thing you have to delve into in your community. Is your community wanting to utilize long-term incarceration as a response to crime? The next thing you have to consider is one of the primary reasons a tribe may want to enact enhanced sentencing is in situations when the United States, if you're in a non-280 state, or the state, if you're in a 280 state, is simply not doing an adequate enough job punishing serious offenses. Even though the Tribal Law and Order Act was one of the goals was to lower the declination rate of the United States regarding serious crime, there's still tribal communities where the United States still declines a majority of major crimes referred to them. And in that scenario, if the tribe does not have the substantive laws in place to adequately punish that crime, you can have a situation where a serious violent offender is not adequately punished for serious crime. I recall 15 years ago hearing a case involving a manslaughter, a person driving recklessly while intoxicated, killing a passenger. And at that time, the tribe did not have manslaughter as a crime. The United States declined the case. The most we could do under the tribal code was careless driving, which carried a $50 fine. And there's a situation where, because the tribe's substantive law was a little weak, a person who probably should have been incarcerated long term only paid a fine. So it's critical that you assess in your community, is the United States or state, if you're a 280, adequately punishing serious crime? You should also be aware of a case that's now been argued to the U.S. Supreme Court. I think it's called Gamble versus United States. It was argued last week. As many of you know, a tribe and a federal government can prosecute the same crime. It's called the dual sovereign rule. The notion being double jeopardy is not violated when two separate sovereigns prosecute the same crime. However, there's a challenge to that before the U.S. Supreme Court. And in that challenge, I was looking at the argument, the issue of tribal federal prosecution came up. So if the Supreme Court overturns the dual sovereign rule, tribes have to be aware of that. You would not want, for example, a situation where an Indian tribe prosecutes a murder, for example, punishes the offender, the maximum would be 3 years under TLOA, and then have that prosecution bar a subsequent federal prosecution. So we all have to be cognizant of that. The next thing you have to make sure your community is aware of and your tribal citizens, it's quite possible that if a tribe enacts enhanced sentencing, that the people you convict in your court of these crimes could be felons. And as many of you know, being a felon in certain states lose a lot of privileges. I know in South Dakota, you don't have the right to vote, for example. And it would be ironic, considering the fact that we just went through an election season where in some states there was an attempt to disenfranchise Native people, that tribes themselves essentially disenfranchise their members by imposing felony sentences. Now, this is especially important if you participate in that tribal access program, the TAP, because as part of participating in that, you agree that your convictions can be shared in certain databases, federal databases. Some of these are available to states. So if you do convict people of offenses that appear to be felony offenses, there may be some certain privileges, civil rights that these people do lose. The next thing you have to ask before you look at passing a code, do you have the resources in place to fully carry this out? Do you have the required judicial officers? Do you have probation officers? Because this is long-term probation. If you are looking at punishing someone up to 3 years and at maximum 9 years, actually, for one criminal transaction. And the next thing, you have to have adequate defense counsel, and not just one or two public defenders. Many of the cases I'm familiar with involving felony drug crimes, there are multiple defendants involved. So in that situation, you have to have a ability to have conflict counsel appointed when the public defenders are conflicted out. And then lastly, it's something we're focusing heavily on in the curriculum. What are you going to do with people you incarcerate up to 9 years? TLOA does have provisions that talk about what facilities you can utilize. If you're using a tribal facility, it must be certified by the BIA. However, it also says you can use a county facility. But we have to make sure if a tribal community embarks upon enhanced sentencing that we have humane correctional facilities available. I have a situation right now. Unfortunately, at Sisseton and Wahpeton, we had the situation where the BIA shut down our jail. It was a very old jail. It was actually only a temporary holding facility we were using as a jail. And now whenever we incarcerate someone long term, which is really more than 30 days, the BIA is required to transfer those persons to BIA facilities. We had a situation recently where a young man who was convicted of several drug offenses and sexual assault offenses received a 9-year jail sentence. And the BIA balked at transferring him to any facility because he had some mental health issues. So now we have a young man sitting in a county jail for 9 years. And some may question whether that's even constitutional or whether that violates the Indian Civil Rights Act. So all of these are considerations you have to look at in your community before you embark upon passing a code. Because passing the code is the easy part. Implementing the code and providing resources to persons that you have convicted That's another thing that you have to examine. Next slide, Travis. And that's, you may have think that I just talked about a lot of negative things or reasons not to implement enhanced sentencing. But let me give you a couple of the primary reasons tribes may want to look at this. And reason one is we still have a lot of serious felony type crime in Indian communities that does not get prosecuted by the United States. And in that situation, if we are not equipped in our tribal systems to prosecute these crimes and impose severe punitive sanctions upon individuals, we may have people who are committing very serious crimes and receiving a slap on the wrist. The other thing, which I think is extremely important, I think the ultimate wish of tribal nations is to be treated truly as sovereign nations by the United States. And when the United States passed the original Indian Civil Rights Act, it imposed a 6-month limitation upon tribes when they incarcerate. Later, it was expanded to 1 year. Now it's 3 years, with a maximum of 9 years for one criminal transaction. Ultimately, many tribes want all limitations released, that there be no federal limitations on the authority of Indian tribes to punish crime. That would be the ultimate aspect of sovereignty tribes are looking at. However, if the United States looks out at the landscape and sees that only 14 to 15 Indian tribes are exercising enhanced sentencing under TLOA, that may cause the United States to believe that tribes don't want this jurisdiction, this sovereignty restored to them. So I think it's really important. This may be a litmus test for us in Indian country. Do we really want to have the authority to prosecute without limits imposed by the federal government? So that's something we have to look at. That's certainly one of the reasons tribes may want to exercise this enhanced sentencing and pass a code. Okay, now let's get to the next slide. What kinds of crimes can a tribe impose enhanced sentencing? And under the Tribal Law and Order Act, an Indian tribe can impose a sentence up to 3 years per count and up to 9 years for one criminal transaction. So, for example, if an individual is operating a motor vehicle while under the influence, wrecks the vehicle, injures a passenger, the police officer appears, the individual assaults the police officer, that's an entire criminal transaction. Each count of that, if the tribe has considered that a felony or a penalty of enhanced sentence, is limited to 3 years incarceration, total of 9 years. What kinds of crimes can a tribe impose these enhanced sentences on? This is what TLOA says. Tribes can impose felony type offenses up to 3 years upon individuals convicted of a crime in your jurisdiction where they have been previously convicted of the same or comparable crime in your jurisdiction or another jurisdiction in the United States. That would be state, federal, or another tribal court has convicted that person. Or the person is being prosecuted for an offense that would be punished by more than 1 year of imprisonment if prosecuted by the federal government or any of the states. And notice this does not say if subject to more than 1 year punishment by the state where the tribe is located. It says any of the states. This is basically a blank check for tribes to define what types of offenses should be considered felony type offenses. So that's what the statute states when the tribe can impose an enhanced sentence. Next slide. Okay, we're not going to talk too much about this provision of the Indian Civil Rights Act. This will be in future webinars that APPA and TJI conduct. I want to point you, though, to number 4 of what is required for an Indian tribe to exercise enhanced sentencing. The tribe has to make the criminal laws, rules of procedure, rules of evidence publicly available prior to exercising this authority, including a method of recusing judges. So if the tribe wants to exercise enhanced sentencing, one of the first steps is you have to publicly make available your criminal laws, that's your substantive laws, your penal code or your criminal code, your rules of evidence, which I'm going to talk about in this webinar because many tribes are very weak in that area. We don't have rules of evidence in our code. Sometimes tribes say, well, we just apply the federal rules or the state rules. That has to be laid out in some type of written format and made available to the public. Also, criminal procedure rules have to be publicly made available before a tribe can do this. Now, I'm going to go into a discussion on what some tribes have done. Next slide, Travis. The National Congress of American Indians and the Tribal Law and Policy Institute have an excellent website where they have put online all the tribal codes of tribes who have implemented enhanced sentencing. And it's available at that link that I put on this particular slide. Look at that. Now, that's not to say that if you are a tribe that are looking to enact enhanced sentencing, that you should just copy what some of these other tribes have done. Because when we look at some particular examples from these tribes, we'll see that many tribes have expanded this definition of a felony type offense to include things that other tribes may feel should not be felony type offenses. Our experience at Sissa and Wahpeton, for example, after the tribal elderly approached the council, the tribal council passed a Controlled Substances Act. It is included in this link here that NCAI and Tribal Law and Policy have. But it made almost every offense associated with methamphetamine a felony. Manufacturing, distribution, possession, and even made ingestion of methamphetamine, first offense, a felony. Now, within 6 months of passage of this law, we probably had over 100 felonies charged out, most of them ingestion of methamphetamine. And as a result of that, many people went back to the tribal council and said, you know, we're felonizing too many tribal members for substance abuse problems. Maybe we should not make these felonies. And the tribal council amended the code retroactively to make these misdemeanors. So I understand some people's belief that if you punish a crime more harshly, you more effectively curtail criminal activity in your community. But when it comes to drugs, it does not appear that that works very well. I mean, the war on drugs in the federal government did not seem to work very well. So many tribes, though, probably are going to look at this and decide whether making drug crimes, for example, felony offenses, is a wise move. Okay, now let me delve into what some tribes have done. Okay, remember under TLOA, the first type of offense that a tribe can subject to enhanced sentencing is an offense where the person has already been convicted in federal, state, or another tribal court, or your tribal court, of the same offense. These are oftentimes called habitual offender laws, career offender laws. Sometimes it's referred to 3 strikes and you're out. but these are people who habitually commit the same crime. And probably the number one choice that tribes have to impose habitual offender enhanced sentencing is on domestic abuse offenders. Now, one of the reasons tribes have said this may be a good use of this law is if you make habitual domestic abuse a felony, you could apply that to non-Indians under the Violence Against Women Act Special Domestic Violence Jurisdiction, because nothing in that law prohibits a tribe from imposing a felony type sentence. But if you're going to look at making habitual domestic abuse a felony, you probably need to assess how many Native perpetrators do you have compared to non-Native in your community. I mean, if you're running 15-1, Indian perpetrators versus non-Indian, remember, if you want to really point out how serious the tribe considers this crime and punish non-Indians who commit it, you also would be punishing Indian offenders, because there's no way you could pass a code that says only non-Indians get felony sentences for this and Indian perpetrators get misdemeanor sentences. That would blatantly violate the equal protection laws of the Indian Civil Rights Act, and we probably don't want that to be a test case in the federal courts. But it's not limited to domestic abuse. You could multiple DUIs. I mean, most states, second or third driving under the influence offense could be a felony. Narcotics. If someone is habitually using or distributing, manufacturing narcotics, you may want to make it a felony type offense. Now, if you're going to do this and you're going to rely upon convictions from other jurisdictions, most likely you're going to have to prove that those prior convictions met the standards of the law where that conviction arose. Now, because we have a U.S. Supreme Court case called U.S. versus Bryant, and in that particular case, the court said tribal convictions can be utilized even in federal court to prosecute someone charged with habitual domestic violence, even if the tribal conviction was not a counseled conviction, meaning the defendant was not given counsel. However, remember, if the prior conviction is a state or a federal offense, state or federal courts generally require legal counsel for indigent persons. So you may very well have a situation where when you prosecute someone for a felony type offense, habitual domestic abuse, for example, your prosecutors have to show those prior convictions are valid. And then another issue that may come up is, and you have to address this in your code, does the prosecutor have to prove beyond a reasonable doubt that that person was convicted by another jurisdiction, or is that simply a sentencing issue? If the person's been convicted by the tribe, can the prosecutor just bring in prior convictions in other courts and say, now the person can be charged and sentenced for a felony type offense? These are all things you have to look at when you want to use habitual offender status as a felony. And here's some examples. I give example, the next slide, Pasquayaki. Pasquayaki has a domestic violence habitual offender offense. Now, it is not a felony under Pasquayaki law. It's still a misdemeanor. But I just give you an example. There, a person who has had 3 prior convictions within the last 7 years is charged with habitual domestic violence. And this can be made a felony. Pasquayaki has decided not to make it a felony, but your community could make it a felony. You could impose a sentence up to 3 years if a person has been convicted of 2 prior domestic abuse charges. Or perhaps the person has violated a protection order 2 prior times. You may make that a felony. But remember all the ramifications of doing that. I also throw in Sisseton-Wapadan's ingestion law. A third offense is a felony under tribal law. and it's subjected to some pretty harsh penalties, even the possibility of banishment. So that's type 1 of the offenses you can put in your codes that are subjected to enhanced sentencing, habitual offender type crimes. Now, the next type, again, in the next slide, offenses which would be subjected to more than 1 year incarceration if charged in federal or state court. This is extremely broad. Extremely broad. When Sisseton and Wahpeton, for example, initially legislated that an ingestion should be a felony, first-time ingestion of methamphetamine, I had a defense attorney challenge that and argue that ingestion of methamphetamine is not even a crime under federal law, which it's true. There's not many states punish having the drug in your bloodstream. However, the state of South Dakota had that as a felony in their code. So under the Tribal Law and Order Act, if you can locate one state apparently that makes a crime subject to more than 1 year, you can impose enhanced sentencing upon that in accordance with the Tribal Law and Order Act. And even the domestic abuse, first offense, some states consider that a felony, even when there's not serious harm to the survivor of abuse. Some states make animal cruelty a felony. So you really have broad discretion here if you're a tribe looking to impose enhanced sentencing. But what comes with discretion is the need to utilize it wisely in a way that meets your community's needs and after an assessment of whether you have the resources to do this. Because, for example, if you believe that methamphetamine is a serious problem in your community and you want to impose maximum punishment for it, you better have the resources to deal with the consequences of having perhaps hundreds of your fellow tribal members convicted of these offenses. But remember, the standard is any state or the federal government has this particular offense subject to more than 1 year, then the tribe can make it subject to more than 1 year. Now, the next slide, I give a suggestion for what types of substantive offenses that you should perhaps make subject to more than 1 year by referring to the Major Crimes Act. Remember, the Major Crimes Act gives the federal government jurisdiction to prosecute any Indian person who commits one of these major crimes against another Indian or non-Indian. Over the years, the numbers of crimes under the Major Crimes Act giving the federal courts jurisdiction have expanded. The most recent one, I believe, is felony child abuse or neglect, which, interestingly enough, the definition of felony abuse or neglect is defined under state law, not tribal law. But as you can tell from this list, this has some pretty serious offenses. Just because it's there, though, does not mean the United States is going to prosecute it. Especially some of the assault offenses. I still don't understand the standard that the United States utilizes to determine aggravated assault or assault with a deadly weapon or assault resulting in grievous bodily injury. It seems that state to state or even district to district, there's a different standard for that. I mean, I presided over cases where victims of domestic assault have had broken noses, broken arms, various broken bones, but apparently they don't meet the standard under the Major Crimes Act. So as a result, you have to be prepared in your community to impose appropriate punishment for some of these offenses if the United States declines to prosecute. So you may want to look at all the offenses under the Major Crimes Act, make sure you have a code that makes these crimes A, illegal, and B, subject to appropriate punishment. Because if the United States declines then your obligation as the tribe is to make sure there's justice for the victim of these offenses, but also accountability for the perpetrators. So I would suggest you look at these major crimes, make sure your code makes them felonies or subject to enhanced sentencing. Now, let's look at what other tribes have done. And I went through a lot of the tribes on the next slide to give you examples of what tribes have done in the area of imposing enhanced sentencing. Fort Peck in Montana. Fort Peck, for example, has an offense, custodial interference. If a person interferes with custody of a child in foster care, for example, removes a child, if a parent removes a child or entices a child away from a foster home, that could be a felony offense. Now, is that a legitimate use of tribal authority under TLOA? Well, all the tribe has to do is demonstrate that that would be an offense if prosecuted by the federal or state government that could garner a sentence more than a year. And most states do make this a felony offense. So Fort Peck has seen fit to make this a felony offense in their code. Now, I'll give you a lot of examples from Umatilla. And if you review the Umatilla code, Umatilla has decided to make a lot of offenses felony type offenses. Perjury. If a person swears falsely regarding a statement in regard to material issue, could be a perjury offense. It's a felony under Umatilla law. Now, this is not only swearing falsely in a court of law. If you work in tribal systems, you realize when people file petitions, they're supposed to swear to these statements under oath. And Umatilla apparently believes that perhaps lying under oath is such a serious matter, needs to be a felony. Look at the next example. Umatilla, if you fail to appear for court and you're charged with a felony, your failure to appear is another felony. And this is a typical thing states utilize. Now, speaking from my experience, we have a lot of people that fail to appear for a criminal proceeding, misdemeanor and felony. And it doesn't seem to matter if you impose a heavy bond on them. Some tribal communities only make failure to appear subject to bond revocation. Umatilla makes it a felony. So if you're charged with a felony offense, don't appear, that's another felony. Again, it's up to your community to determine if that's appropriate punishment. One that Umatilla does make a felony, assaulting a law enforcement officer, which is an offense I see a lot of in many tribal communities. Generally, the federal government doesn't get involved in this unless the BIA officer is the victim, or sometimes when a tribal officer who's certified to make federal arrests is a victim. But a lot of times our tribal officers who are employed by the tribe, are subjected to a lot of abuse. Umatilla decides you want to assault a police officer or a firefighter, you're looking at a felony. Again, it's up to your community to determine what should be felonies. Now, another thing you may want to cover in your code, and I give an example in the next slide, is how are people supposed to serve sentences? This is an example from the Choctaw Tribe of Oklahoma, which directs how persons are going to serve offenses more than a year. And when we have a webinar session on corrections, we'll see that TLOA does put restrictions on where you can place prisoners long term. There's really no restrictions under TLOA on short-term prisoners less than a year. There are Indian Civil Rights Act restrictions. You cannot expose them to cruel and unusual punishment, which has never really been defined in Indian country. If you visit some tribal jails and look at them, they may actually meet the definition of cruel and unusual punishment. But if you're going to impose enhanced sentencing on defendants, you have to have a plan. If you have a tribal facility, you've got to get it certified. There used to be a Bureau of Prisons pilot project where tribes could incarcerate people in the Bureau of Prisons. Now that, as far as I know, that ended, has not been renewed. There's talk about renewing it. Or the most confusing one is perhaps the third option: incarcerate in a state or local government jail. Now, the confusion is created because there's nothing, most of these county jails are not accustomed to incarcerating people more than a year. Surprisingly, though, TLOA doesn't say that county facilities have to meet any standards for long-term prisoners. So some believe, therefore, that if the tribe simply places their prisoners, long-term prisoners, in a county jail, that satisfies TLOA, regardless of the condition of that jail, regardless of what services are provided inmates in that jail. So this is an open question we're going to discuss when we do a webinar on corrections. Now, another thing that TLOA does not address, but some tribes are starting to address, is imposing banishment upon individuals who receive enhanced sentences. And here is Eastern Cherokee Code. If you note from Eastern Cherokee, if you get a sentence, mandatory 1-year sentence or higher, you're also subjected to banishment. Minimum period of banishment up to a maximum of 10 years. TLOA does not really regulate this. Some have argued that nowhere in TLOA does it say enhanced sentencing includes banishment, but banishment is an inherent right of Indian tribes. Whether or not you want to put it in your code, though, is up to your community. I know we have it in our drug code, assisted in Wahpeton. Unfortunately, though, it's left up to the tribal council. As a judge, I would be very uncomfortable deciding whether to banish a person for up to 10 years. So you have to define that in your code. But banishment, people have to be put on notice if banishment's a possible penalty. Okay, now, if you're going to enact enhanced sentencing, I would recommend that you do what some tribes have done, and I show you in the next slide. Have some possibility of redemption through remedial measures in your code. One thing we utilize a lot of is suspended impositions of sentences, or what's called deferred imposition of sentence. And I give you an example from the Assisted in Wahpeton Code. These are people who commit felony type offenses. However, the court has discretion to suspend imposition of their sentence, basically meaning they're found guilty, but they're not sentenced. Instead, they're put on probation, and if they successfully serve out their probation, they can go back to the court and ask that the charge be dismissed. And in this way, they have the right to get this charge dismissed, and they don't have to go forward with the status of perhaps being a convicted felon. Another possibility is giving the tribal prosecutor discretion to defer prosecution of a case. That has to be in the code, though. A tribal prosecutor doesn't have the inherent right to do that, to defer prosecution, unless the tribal code gives that to the prosecutor. Another possibility, create a tribal pardon board or clemency board. Remember, these people, perhaps when they're young, they commit offenses. If you give them no option to get that record removed, they carry with them the rest of their lives, that particular status. Okay, a couple more slides and we'll open it up for questions. There's other provisions you have to have in your code. Again, these must be published, meaning you can post them online. You have to put them in writing, but defendants must be aware of these rules of procedure, rules of evidence. Again, I've read lots of tribal codes that have no rules of evidence in criminal proceedings at all. And the tribe will tell you, well, we go by the federal rules. Well, if that's true, you've got to put that in writing somewhere. Maybe get the tribal council to pass a resolution directing that the court apply the federal rules of evidence, put that in your code, or publish that online. Because if that's lacking, you're violating the Tribal Law and Order Act by imposing enhanced sentences. Well, you're probably violating the Indian Civil Rights Act too, by not giving people notice of the rules of evidence and procedure in place. So these are just some examples. Again, I'm not giving you these examples to say you should incorporate these into your code. It just shows you the breadth of tribal codes out there with regard to what tribes have made subject to enhanced sentences. But please, if you think about code drafting is the easy thing. Getting your community to buy into enhanced sentencing and understanding all the ramifications is the difficult part. If you embark upon this without community input, without community buy-in, you could have a very upset tribal membership. But in your community, if you believe that crime is at the point where these sentences are appropriate remedies for that crime, by passing these laws, exercising this right, I think it shows the United States that tribes are prepared to exercise the full panoply of sovereign rights they should have in criminal proceedings, and that Congress was wrong when it limited tribal sentencing authority. If we exercise this reasonably, maybe the next step is 10 years, maybe the next step is 20 years. Maybe then Congress will totally eliminate all restrictions on tribal authority, and tribes can truly exercise those sovereign powers that they deservedly should be able to exercise. All right, I said I would leave it open for a few questions. And then also if Narina Henry had joined us, I don't know if Narina did, but Narina is the project manager for this particular curriculum we are developing. I don't know if she had anything to add or if anybody from APPA had joined us. But otherwise, we could probably take some questions, Travis, if there are any questions out there.
Yeah, of course. We've already got one that came in about halfway through the webinar from Ms. Perry, so we appreciate that, Ms. Perry. Ms. Perry's tribe is already exercising enhanced sentencing, and they're about to be a part of the TAP program, BJ, and they're going to have a community meeting in February to discuss alternatives for penalizing persons convicted of drug offenses. Do you have any thoughts or ideas on good alternatives other than jail?
Well, I mentioned the suspended imposition of sentence option because if you're participating in the TAP program, my understanding is the federal government believes that a quid pro quo of participating in that is that we share our convictions with the federal government as well as the state governments. So if you are a tribe that want to look at alternatives to long-term sentences for drugs, you may want to consider the suspended imposition route, because not only does that give a person a chance to show they can be rehabilitated, but as part of that suspended imposition, you can order people to go to treatment. You can order them to be subjected to UAs. And the good thing about it is if they violate continually, then you can go back and have the judge impose the sentence, and they would be considered I don't want to say felon, but subjected to enhanced sentencing. So that's a good alternative. A deferred prosecution where the tribe will say, if you agree to do certain things, go to treatment, be on probation for a certain number of years, and then if that person follows through, the tribe would drop the charge. So I think I'm really glad this question came up, because I know a lot of tribes are looking to use this enhanced sentencing to deal with drugs in their community. And I agree. Methamphetamine especially has really ravaged many tribal communities, and we have to respond in a very tough way. but I'm glad you're looking at alternatives to just imposing the sentence, because if you give someone 3 years for possession of methamphetamine, if you don't have any type of parole system, if you don't have any type of rehabilitative services in jail, then essentially they're doing 3 years without getting any help for their substance abuse problem. So there are alternatives, and I would urge you to look at some of the tribal codes to see how tribes have provided alternatives. Of course, there's always wellness court, drug court, and many of these drug courts, tribal prosecutor will defer prosecution, or the person will get a suspended sentence or suspended imposition. If they go through an extensive drug court program, graduate, then many tribes would expunge that conviction, meaning eliminate it, so the person no longer is considered a felon or a person that was subjected to enhanced sentencing. So there's a couple of examples you could do in your code.
Okay, BJ, that's the only question that I've had come in so far. We were joined by Narina. I don't know if you wanted to say anything, Narina, and I don't want to feel like I'm pressuring you. That's the only question I've got. So if there's no more questions, I'd like to thank everybody for attending. And like I said, we'll get this uploaded to YouTube. And if you're interested in the PowerPoint, I can send it out to everybody as well. Just maybe give everybody a few more minutes to see if there's another question. And I think we do have another question here, BJ. Let me see if I can find it for you. Oh, no, never mind. All right, everybody. Well, thank you for coming, and I'll send the PowerPoint out to everybody and upload the link to YouTube. Thanks, guys.
Thank you, everyone.